even let's say 50 or 60 years down the line, and doesn't ossify as a fossil, so to speak, making it inapplicable. The idea is to unshackle it from the perceived rigidity that is associated with, let's say, positivism or literalism, constitutional literalism. Okay, so I do believe that perhaps there is a middle ground to be struck between being a hardcore positivist, at the same time a hardcore TCist, so to speak, for two reasons. One, a literalist effectively forgets the nature of the document because it is not just any other statute. It is not just any other act. It is the supreme legislation, and therefore the latitude with which you're supposed to read this particular document is significantly more than any other document, any other legal instrument, so to speak. So the Constitution effectively has two aspects where there are certain principles of statutory interpretation which otherwise apply to the Constitution, but there are certain principles which are exclusively reserved for the purposes of constitutional interpretation, which are very different from principles of statutory interpretation. So that's point number one. Point number two is when you decide to become an extreme TCist, so to speak, then you're effectively saying that the ends justify the means, and therefore every provision of the Constitution becomes vulnerable and susceptible to individual interpretation and to individual proclivities and ideologies. Therefore, there is a problem with both extremes. However, what we are discussing is what is ideal, whether it is desirable, so to speak, or not. The first question that I would answer is, since the judiciary itself is bound by the doctrine of separation of powers, any interpretation of the TC document or any application of the TC doctrine must necessarily be consistent with the principle of separation of powers or the doctrine of separation of powers. Okay. Therefore, whether it is desirable or undesirable is a different issue. But if the exercise of this particular doctrine translates to ingress and transgression into the powers of other organs of the state, then effectively, notwithstanding the best of intentions, the judiciary would have facilitated a violation of a doctrine that it has invented, which is the basic structure doctrine. Okay. Therefore, I am not against the principle. I would simply say that principle can be applied to a significant measure to those provisions which lend themselves to the application of that particular principle in a manner which is consistent with the doctrine of separation of powers. So why should I make this so vague? Let me make it very specific. Let's take Article 21 for a moment. Okay. The language of Article 21, which specifically speaks of right to life, is drafted and crafted with such breadth so that right to life can accommodate within it multiple rights as and when the time calls for it, and then you're able to cull out and distill multiple rights from that particular provision itself. So transformative constitutionalism is perfectly an acceptable doctrine for the purposes of Article 21, because the language of that particular provision is drafted in a way so as to make it a bundle of justiciable rights which the judiciary can recognize as the time progresses. Okay? But certain provisions which have a very, very specific history and a very specific intent, when they are sought to be made subject to TC, the doctrine of TC, then not only do you do justice and violence to the intent of the Constitution, you also go against other rights which are enshrined in the Constitution and other powers which are available to other organs of the state. So let me take the Sabarimala case itself as an example. So for instance, the most significant point of departure and divergence was the application of Article 17, which is the provision relating to untouchability to the practice of the Sabarimala temple. So despite the fact that I'm an interested party in the outcome and I'm someone who's associated with the matter, let me state it on record that it is perfectly legitimate for anybody to hold a position that such a practice is perhaps violative of somebody's individual rights of freedom. Okay, I'm not going to brand it an unreasonable principle or an unreasonable position. I'm merely going to say that perhaps people don't understand the practice, or even if they understand the practice, they disagree with the practice because their worldviews are different. I'm perfectly comfortable accommodating even that position. However, to brand that principle in the basket of and put it in the basket of untouchability was too extreme for two reasons. So one, On merits, that particular practice, frankly, does not merit to be labeled as untouchability. That's a different issue altogether. I don't wish to get into that. Let me address that particular argument from the standpoint of your question. Untouchability has a very specific discussion in the Constituent Assembly debates, which is caste-based untouchability, birth-based untouchability. The entire discourse around the caste system within the four corners of the Constituent Assembly debates and the history of the Constitution tells us that it revolves around certain stigma which are associated with birth, not because of what you do, but where you come from. And it is effectively decided by the womb that you're born to or born from. And therefore, to address that specific issue, untouchability finds at least two strong references in the Constitution. In fact, I would say three. Article 15 is one place, Article 17 is another, and Article 25(2)(b) is another. 15 having more or less the same principle as 17, but 17 taking perhaps the most clear and categorical position and unequivocal position with respect to untouchability. And 25(2)(b) being a specific tributary from that particular position with respect to temples, to say that you cannot prevent somebody's entry into that particular temple on grounds of untouchability. Therefore, when you look at 17, 15 and 25(2)(b), there is a specific intention which is based on history, on a specific portion of history. Now, importantly, the untouchability that is being discussed as part of that particular articles, both 17 and 25, it is societal untouchability, which is to say, you will be treated as an untouchable because of your birth, regardless of the place in discussion. Okay, whether it's a temple or a secular place doesn't make a difference. So you would be an untouchable even for the purposes of temple and outside of that particular temple, but you're primarily treated as socially untouchable. Okay, now this is very, very different from the concept of ritualistic practices which are followed in a particular place. Okay, therefore, the application of TC to this particular instance and to this particular institution, not only did it do injustice to the practice of the particular temple, it also asks, it forgot to ask itself this question. 17 has a specific consequence, 25(1) and 17 have a certain interaction, 17, 25(1) and 25(2)(b) have a different level of interaction, 17, 25(1), 25(b) and 26 have a different level of interaction. Most importantly, if you take a look at 25(2), it gives the state the power to initiate reform through legislation. So if the judiciary decides to use TC doctrine, the doctrine of TC, to extrapolate untouchability to all those places which are independent of the history in which untouchability has been used in the Constituent Assembly debates, then what the state is supposed to do for the interest of reform and in the interest of reform through a legislation, the judiciary has taken upon itself to do the same thing without awaiting social cogitation, without awaiting a critical mass of opinion, without awaiting a legislative call or an executive call with respect to the particular practice. So this is a specific instance where the doctrine of transformative constitutionalism effectively transgresses, or let's say does violence to the history of Article 17, in addition to doing injustice to institutional fundamental rights under Articles 25 and 26, and also does violence to the doctrine of separation of powers, because the state has a certain power which now the judiciary has arrogated to itself by using this doctrine. I am not going to call this doctrine a doctrine of convenience, but its application is certainly of convenience in certain instances. And this is where I'm striking the distinction between the application of this doctrine to Article 21 and the application of this doctrine to Article 17. 21 necessarily has a certain degree of bandwidth and latitude, which the judiciary is entitled to exercise as part of any petition under Article 32. Because the judiciary is going to ask itself, have certain set of rights acquired a fundamental status over a certain point of time, warranting their recognition when a certain legislation or a certain piece of state action is challenged as part of Article 32, citing violation of right to life. But Article 17 is not one such instance because there is a very specific history. Because if Sabrimala's interpretation and application of the doctrine of TC to this practice were to be accepted, I'm sorry to say from there it's only a slippery slope and it's a downward slope whose gradient is extremely sharp, because every ritualistic practice in every religious institution is now going to be tested on the anvils of untouchability. Because if somebody decides to observe a limited notion of ritualistic purity for the purposes of a specific space, even if it's a religious space, now he's going to be or she is going to be accused of untouchability. And even in the confines of home, tomorrow if somebody decides to make a certain practice, that is going to be branded untouchability. So where does this end? Apart from the question of where does this end, if there is a specific provision that empowers another organ of the state to take a call with respect to these practices, for the judiciary to use this doctrine is a convenient but dangerous launchpad for such instances. So I am not someone who comes strictly from the positivist school of thought. I do believe that the document must be treated as a fluid document to meet certain exigencies. I have no problems with that. But on the one hand, when it comes to certain other developments like Article 370, we want to stick to the history of the Constitution. We want to stick to the literal language of the Constitution, the intention of the framers of the Constitution, the promises made under a certain document. And we want to apply transformative constitutionalism to other parts of the Constitution. So there seems to be a very, very convenient approach to this, depending on which side of the ideological divide, so to speak, one occupies. Okay, so clearly, the application of TC, I don't think can be denied in this day and age, because the progress of constitutional law has made it possible for us to accept this particular doctrine as perhaps the way forward in significant ways. But can you do that regardless of and divorce the history of certain specific provisions, which is why I said the entire document cannot be treated as a document which enables the application of TC. Certain portions are, and that depends on the language. So what am I doing? I'm combining a positivist approach as well as a TC approach to say, where the language of a certain provision enables the application of the doctrine of TC, then positivism itself enables TCism. And where the language is tied to specific history, which is rooted in a specific discussion and in a specific social context, then applying TC effectively translates to not judicial activism, judge-based activism, which is dangerous. Judicial activism is not to be confused with judge-based activism, because judicial activism is institutional activism. Just judge-based activism is individual activism, where your independent notions of what is right and what is wrong are being foisted on the rest of the society when you have not been elected for this particular purpose. You have never been elected. Your procedure for appointment is very different. That itself is the subject of contention. Therefore, a body which believes that it cannot be supervised by any other arm of the state must act with greater circumspection and caution in applying these kind of doctrines, especially in social as well as in religious contexts.
Okay, I think there's we have already found a lot of fodder in what you have already spoken, and I will just open the floor to all the students so that they can have a direct interaction with you. And I would request the students to raise their hands if they have any questions. I'll just make one observation regarding what you said, Sai, mostly agreeing with you. One is that, first of all, you said you tried to make a balance between, you know, a positivist textualist approach and the TC approach, which I, as a faculty of interpretation of statutes, find a little problematic. I'm a little rigid in the sense that, because I do not think a historical inquiry into what resulted into the text of the Constitution is really a judge's job. So it is equally vulnerable to the doctrine of separation of power. And so, yes, as long as the judge can read it in the language of the Constitution, you know, applying all the canons of interpretation that are available. And of course, a constitution being the foundational document allows more, you know, more relaxed methods of, you know, interpretation or broad, you know, interpretation of the text. To that, I do agree, but I do not think that an inquiry into the, you know, into the history of the constitution making, or for that matter, because it started with the history of the Indian independence movement, has is really the you know, the judge's playground. So I do not.
That's okay.
Sure.
Yeah. Applying the principles of interpretation of, let's say, statute, so to speak, I can't disagree with you. I have no reason to disagree with you. Okay, which is why I chose my example very, very carefully. I landed on Article 17 for a very good reason, which is, if the language of the provision is crystal clear, there is no problem. But if the language of the provision points to a certain context, it necessarily drags you into history. Therefore, when a word such as untouchability is used in Article 17, A traditional approach with this, let's say, a principle of statutory interpretation cannot be applied because effectively everything boils down to one question, which is what is untouchability? Okay. And since there is no other document, or let's say there is no other provision of the Constitution which spells out a definition of metes and bounds of untouchability, this is one such provision where rules of interpretation would necessarily lead you in the direction of looking at history for the simple reason, not because this is ambiguous or that this is capable of multiple interpretations, but because the language of the provision specifically speaks of a certain context. So let me just caveat my position by saying an external aid of interpretation is not necessarily to be relied upon only when there are multiple interpretations possible or when there are two, let's say, conflicting interpretations possible. But when there is a specific context that the language itself makes clear by the use of certain terms, then you have no other option. So let me give you another example. Let's take Article 370, this controversial provision. Every discussion around Article 370, notwithstanding what the provision expressly says, would be an ahistoric discussion unless and until the terms of accession and the terms of negotiation between the princely state and the Indian Dominion is actually looked into. Okay, certain provisions by default require a historical approach, notwithstanding what the language is bound to say, because language on the face of it, let's say, is bound to say if you're stopped from touching another person, yes, that's untouchability. If you effectively practice social distancing, that is untouchability. But that is not the context. And if certain provisions have very specific contexts, I don't think it can be argued that principles of statutory interpretation come in the way of your ability to look at that specific context. Then the question will be slightly different. What will be the principle of interpretation that I think you can perhaps apply there is the language necessarily limited only to the context? That is where the principle of interpretation comes in, which is to say, there may be a certain context, but am I necessarily bound only by that particular context and restricted by that particular context? That is where the second level of the question arises. However, the relevance of history to such provisions continues. It is then a second question of the judge's procurability coupled with principles of interpretation to ask, why should I necessarily be tied down only by this particular history? Why can't I apply it to other places? And that is where you effectively ask yourself, which other rights are bound to be affected by such extrapolation? Which other entity or organ's powers are going to be affected by such extrapolation? That is why I specifically chose Article 17, because you mentioned Sabarimala. It is not my case that for every provision of the Constitution, see, I'm going to be very, very clear. I am not going to take an extreme position on any of these issues because my limited experience of applying constitutional law and other laws in court in action tells me that the circumstance effectively changes your approach to certain provisions. It forces you to revisit provisions in a different light. Had it not been for, let's say, a practice like Sabarimala, would we have thought of applying the argument of untouchability at all to religious spaces in the context of ritualistic purity and ritualistic impurity? That itself is the subject of the Constituent Assembly discussions. In fact, there are several people who had spoken on this particular issue, and that even made the argument that leaving untouchability undefined in this particular fashion is bound to lead to busybody litigation, because even ritualistic impurity would effectively fall within the scope of untouchability when left undefined under Article 17. That was one of the things that was discussed in the Constituent Assembly debates. So I am not going to say that every time we discuss the Constitution, you always have to look at the history. But yes, for certain provisions, a look at the history is inevitable, but whether you're bound by history or not will have to be decided by whether the provision is basically asking you to limit yourself to its historical context.
All right, I think a lot of hands have already been raised, and Arindam, who was first?
My only request is anybody who asks me questions, apart from introduction, I'd like to know which year.
Okay.
So we had a Samir Guduru who raised his hand first, and then we had Arindam, then Ramya, and then the rest are in the chat box.
Okay. Samir, is there a Samir in the audience? You can unmute yourself and ask the question. Yes, please, go ahead. Go ahead.
Hi, Deepak, sir. Big fan of yours. So my question is slightly more normative in nature.
Yes, please.
So let's say we are undergoing a transformation in this country as far as the politics is concerned. Now, let's say the Hindutva right wing tries to change the nature of the constitution. Should we look at it from the point of view of a maturity in democracy? Like, let's say in the case of France, the country has undergone several transformations. several republics over the years have come up. So should we look at it from that point of view? If you can throw some light into this.
Yeah.
Thank you so much.
I think it's a fantastic question, and it opens the floodgates for, let's say, slightly more provocative responses, because the question is brilliant according to me, and this is the central issue. Samir, I'll rephrase your question. Let me know if I'm rephrasing it in a manner that you intended it. Okay?
Sure.
So, with the ebb and tide of politics and with change in, let's say, the worldview of the dispensations that come to power, okay, does the approach to the constitution also change? And does the interpretation of the constitution also change? Is that your question?
Oh yeah, precisely.
Okay, thanks. Okay. Frankly, I would believe that we would perhaps be mistaken in assuming that the constitution is some kind of an immutable document and is meant to be subjected to some objective standards, notwithstanding any ebb and tide in politics or any change in worldview of the dispensation at the center. In fact, my understanding is that when you look at the document such as a constitution, you need to be a realist to a significant extent, that every dispensation that comes to power comes with the mandate to implement its worldview, whether you like it or not. Okay. The only question that then remains is, what fetters are there in, let's say, the constitution itself, which prevent that particular government from getting away with unconstitutional changes to the constitution? Okay. So that is precisely why I think perhaps to ensure that the constitution is not rendered, let's say, a puppet in the hands of a brute majority, the judiciary was perhaps forced to come up with this particular doctrine called the basic structure doctrine. That said, the constitutional legitimacy of that particular doctrine itself is a serious question, according to me, given that certain references were made to the German constitution, where the German constitution expressly refers to a basic feature doctrine or a basic function doctrine, and therefore it was perfectly legitimate to be invoked in that particular circumstance. Here, judges who are perhaps, I don't think they're, in 1970, I don't know if the collegium system was being followed. I think it was still a case of appointments, and Article 124 was being applied in its letter and spirit. They decide to distill and cull out what they believe are certain immutable basic features of the constitution, notwithstanding the scholarly approach adopted, notwithstanding the rigorous process undertaken. It still remains, according to me, a fair mix of objective as well as subjective analysis. So I don't subscribe to that school of thought which effectively says, no, the constitution is such a holy document that at the end of the day, no matter who occupies power or who attains power, it must be immutable. Impossible. None of the amendments which have been undertaken by the constitution, to the constitution, are necessarily objective changes. Right from the First Amendment, with respect to land reforms as well as Article 19, each of those amendments has been politically motivated. Therefore, to approach the constitution as a document which is uninfluenced by politics, is naive and is ahistoric. I don't think you can approach the constitution with such an academic fervor and with such sense of religiosity as if it's some book which has come from the heavens and it is the product of revelation. It is not. All the more reason why that particular document must be approached with a tinge of realism and with more than let's say, a handful of realism. You need to look at it through political realities. However, no civilizational argument, no religious argument, no political argument can go against what the constitution posits. That is where, to the limited extent, I subscribe to the notion of constitutional morality, which is to say that the constitution, through its express language and its associated history, has taken certain positions with respect to certain values. And to that extent, every dispensation must necessarily abide by those rules which form the basics of the social contract entered into as part of the constitution between the sovereign and the elected. That is the limited extent to which I subscribe to the notion of constitutional morality. I don't subscribe to an amorphous, vague, overbroad definition which effectively says that I will sit and preside over what is right, what is wrong, what is moral, what is immoral, and give it a constitutional facade by giving it the name constitutional morality. However, to the extent that the constitution takes a position with respect to what is the kind of change it can be subjected to by any dispensation, those red lines, that Lakshman Rekha, that bright red lines in certain cases and blurry lines in certain cases, define the metes and bounds of constitutional morality as far as I'm concerned. So one, it is fair game for every political dispensation to choose to want to and to do everything within its power to push its agenda, provided it is within the four corners of the constitution. Now, what has happened over a certain point of time is that we have decided to give every argument a constitutional facade, whether or not it is truly possible to do so, applying the principles of constitution, whether it has any basis in constitution or not. Okay, so unfortunately, thanks to this kind of simplistic approach, the constitution has been subjected to an extreme bit of reductionism, where we effectively approach, because I've had a lot of discussions even with fairly upcoming practitioners in this particular field. And the notion seems to be that, no, how can we change the constitution? My point is, then what do you think you're being elected for? You're being elected for to be able to push your agenda. Let's be very, very brutally realistic about it. That is the fact. The only question is, where does the buck stop? And what are the hard stops in that particular advancement? That is the only limited question. Otherwise, I absolutely have no illusions or delusions about the fact that this is a document which cannot be approached with, let's say, an academic bent of mind. It can be, if you want to look at it from a policy perspective, but you will always present yourself a truncated picture if you're going to dissociate it from the political incentive or disincentive that a certain move or a constitutional amendment represents. That is a fact. I'd like to see how many constitutional amendments have been undertaken which have not given certain political incentive to the dispensation that has moved it, or that has advanced it, or that has furthered it. It is always catering to a certain vote bank. That is the nature of democracy. There's nothing that we can do about it. Next.
All right. So there are plenty of hands raised, but we have Professor Khagesh Gautam among us, and I cannot, I would really like to hear what Khagesh has to say, because Khagesh says that basic structure is something which he finds inherent in the text of the Constitution. So Khagesh, would you like to make an observation?
I have just one question. Sorry, this is just for the sake of clarity.
Yeah, sorry.
Is this going to be a question? Is this going to be an observation? Because I am given the impression that I've come here to respond to certain questions. So this can't be converted into an opportunity for speech for someone else, because I have agreed for an interactive this thing. So if it is in the form of a specific question and an argument, I'm happy to take it.
Yeah, absolutely, absolutely.
Yes.
Khagesh, do you have a question?
No, I'm afraid I was a faculty member. I thought a comment we appreciated, but I think I'll withdraw what I have to say.
All right, all right. So who was next in? Next in
so we have Arindam, and then Ramya, and then Anujan.
All right, Arindam, would you like to chip in next?
Yes, sir. Thank you. So this is Arindam, final year law student at Jindal. So my question is more pertaining to constitutional morality, because I see there has been a fair sense of, confusion in the sense of, does constitutional morality be synonymous to public morality? Because if I just read the Sabrimala judgment, where I think Justice Deepak Mishra agrees to have it as a synonymous to public morality, since morality in 25(2) is qualified by the word public, both morality, health, and the third word. And so is it synonymous? Because Justice Chandrachud substantially disagrees. Second question, which is in addition to it, is what? Yes. Yes.
So is it what is the relationship between CM and PM? Go ahead. Yes.
Yes, sir. So second question is, to what extent can a constitutional morality be extended? Because if I read cases like the recent LG, the Lieutenant Governor's case in the NCT, where constitutional morality was discussed, then even the Section 377 striking down case, it was discussed. So I have a fair impression that constitutional morality is something which is more a kind of an obligation on the state, rather having an effect on a private life. Because I would like to see it that way, because constitutional morality, all those like people who support it because obviously, as you said, certain provisions have more than a positivist approach, especially things like a pluralistic and a secular approach to it. And I think if a constitutional morality is brought into private life, the very pluralistic character and the democratic character of the constitution might be endangered. So yes, this is what my question is. So what do you think?
So let me answer the first question. So in fact, as part of a book that I'm currently writing, this is an issue that I've specifically addressed. And I've tried my best to do justice to it by drawing from multiple sources. To the extent that I've tried to identify all the origins, or let's say the sources, where public order, law, public morality, and public health have been introduced as restrictions, okay, on certain rights, and which translate to enabling restrictions in the hands of the state, okay. And I think there's this brilliant book on TRIPS and Paris Convention. I think by an author. I'll just share his name. His last name is Gervais. Okay, you'll find it. You Google it. You'll just type public order, morality, law, and Gervais. You'll get it. And he's a fairly established author in the realm of world trade. Okay, basically trade-related instruments. Now he traces the introduction of these limitations primarily to the Paris Convention and similar legislation and similar instruments. Okay, and you know for a fact that Paris Convention is more or less the precursor to the TRIPS in a significant way, to TRIPS and GATT in certain ways, where it ultimately refers to harmonization of principles that apply to IP across the world. Okay, in fact, thanks to my limited exposure to IP in my previous avatar and my current avatar, I got an opportunity to apply that knowledge to the constitution, to principles of constitutional law, to ask myself, where is this limitation exactly coming from? Okay. In fact, he traces that even further, I think, to French law, where public morality and public order have effectively, they have certain synonyms, which is to say good conduct or righteous conduct, so on and so forth. Okay. And I have had the opportunity to read the application of these limitations in at least 3 contexts which are not constitutional in nature, specifically even by the European Patent Office in deciding whether a certain invention should ever be accepted for the purposes of examination on grounds of public morality. Okay. So, because if you look at Section 3 of the Indian Patents Act, public morality is a part of that particular invention as well, because that's the first threshold, or the first filter before you even look at inventiveness, obviousness, and everything else. Okay. And in applying this particular test, European Patent Office makes no bones about the fact that when we apply public morality, we are asking for the application of those mores and values that the European civilization values, that is the language used. And therefore, public morality, contrary to popular assumption, is an indicator of moral diversity, not moral uniformity. Okay. Therefore, public morality is not going to have the same hue in every situation, because you have to, in a country like India, ask whether a certain practice is consistent with the mores and values of a certain region or a place, not the entire country. This country is not a monolith in that particular sense. Okay. When you recognize the sheer diversity of practices in this country, of the culture of this particular country, you can never ever apply public morality as a tool of implementing or enforcing monochromatism. Okay. Neither is it supported by the history of the use of these limitations in other jurisdictions, nor is it supported by the history of the constitution itself in let's say, engrafting these limitations on the state's power, or the state's, not limitations on state, but limitations on individual rights. Okay. Therefore, that itself answers the question whether constitutional morality can be one uniform homogeneous yardstick. It cannot be. Okay. And what is Justice Mishra's interpretation? The word public may come before order, but it is meant to be applied to health as well as to morality. That is how it is supposed to be looked at. Okay. Because that makes sense. You're looking at the impact of the practice not on a certain individual, but on a society. But you're not looking at the entire Indian society, but you're looking at the relevant society in question. Therefore, you have to identify the stakeholders. Since Jindal Global Law School is known for its center on competition law, you have to identify the relevant market. Okay. you have to effectively identify the relevant target audience on whose anvils the question of public morality is going to be discussed. Now, addressing this is effectively connected to your second question, because constitutional morality was effectively brought into picture to say what? You're now making a transition from a certain form of governance to another form of governance. And this form of governance has the document called the Constitution at the top. Okay? And therefore, you cannot resort to a feudalistic style of governance any further in your interaction with the sovereign, because perhaps the degree of your accountability and answerability to the sovereign is even more under this particular document. Therefore, constitutional morality was primarily meant to be a realization on the powers that be, especially the state, that you are not the ruler, you are effectively responsible for governance, not for ruling. There is the conscious distinction that you strike. Okay, this is all the more necessary because, notwithstanding the facade of rule of law, fair play and justice that the British man effectively played in this country, the Indian system was effectively a successor and remains a successor to the Westminster system, and takes significant notions of Anglo-Saxon approach as part of its, let's say, bundle of laws, or its general approach to laws and justice in general. Therefore, the point that was being made was, you may have inherited the skeletal structure left back by a person who was the colonizer, but you are effectively going to treat yourself as an elected sovereign who's subject to the rigors and the rules of the Constitution. Therefore, you shall not treat yourself as some kind of a monarch. Okay? Constitutional morality is meant to be a lesson to not the governed, but to the people who effectively govern, to tell them this constitution is effectively the scope of your rights as well as your duties. Do not assume that what was previously available continues to be available in some form under the constitution. You will decide the extent of encroachment that is available to you with respect to the public's rights and fundamental rights only on the anvils of the constitution. Okay? So in that sense, constitutional morality largely has a vertical application, not a horizontal application. Okay? So we understand and recognize the concept of horizontality and verticality when it comes to fundamental rights in part 3. Okay. So it is impossible to not try and apply these, let's say, these paradigms even to the central question of constitutional morality. Okay. So I don't believe that, first of all, constitutional morality is public morality. In fact, if you were to equate both, again, you end up handing a significant amount of decision-making power on moral questions and on questions of values to the unelected. Okay. So constitutional morality translates to respecting public morality, translates to respecting who gets to decide public morality in a given circumstance, translates to respecting rights which protect certain values and mores as well. So for instance, again, going back to central questions of 25 and 26, a religious practice is not a mere religious practice. Whichever institution or whichever religion you're looking at, it represents a certain thought. It represents a certain way of life, which is why Article 25(1) primarily and firstly protects freedom of thought and conscience. Okay? It is that thought and conscience which is responsible for the associated religious practice, and therefore a certain way of life is being protected. And if that particular way of life and multiple ways of life are sought to be homogenized on the basis of an amorphous definition called constitutional morality, then the fundamental intent of moral diversity, which is enabled and facilitated by the use of public morality, is effectively truncated by CM. Okay? I do not reject the relevance of the application of constitutional morality. My basic position is constitutional morality itself requires you to recognize those islands where the constitution facilitates and allows the proliferation of multiple value systems. And the use of public morality in specific provisions of the constitution is the constitution's way of fostering diversity. And anybody who uses it to kill that particular intent is using constitutional morality to kill diversity when the constitution does not envisage it. Okay? At the same time, let me also go further, okay, which is, there is a significant amount of situations, any number of situations, where public morality would require you to effectively uphold a certain practice on grounds of diversity, but public order may require you to take a slightly different position. So one limitation could have an antithetical position with respect to a practice, and the other limitation could effectively be blessing that particular practice with constitutional validity. Okay? It is in those circumstances where you have to take a call. Now, take a look at those provisions, especially even on Article 25(2). If somebody has the Constitution with them, can I just get a bit clinical here, and I use the language of the Constitution to answer this question. And by the way, your question is so relevant for the simple reason that constitutional morality and transformative constitutionalism necessarily go hand in hand. CM and TC necessarily go hand in hand. TC as a doctrine facilitates the application of constitutional morality. So kindly take a look at just 25(1) and 25(2). And this is where I bring in the argument of separation of powers, coupled with the definition of state, so on and so forth. Now, if you take a look at 25(2), nothing in this article shall affect the operation of any existing law, prevent the state from making any law. Now, 25(2) has been typically interpreted as vesting or enabling the state to pass laws with respect to existing practices or hold existing practices or even abrogate practices. Now, 25(1) isn't clear as to who gets to apply those limitations. It simply says, subject to public order, morality, and health, and other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to practice, so on and so forth. The word state is absent in Article 25(1), right? So who gets to apply those triple limitations is unclear from 25(1) on the basis of the language. And this is where I go back to the earlier question, that the language here makes it unclear as to whether it is the state or is it available for the judiciary to apply limitations under 25(1). But the answer is to be found in 25(2), and the answer is also to be found in the discussion around Article 32 and Articles 12 and 13 in the Constituent Assembly debates, because all of these ultimately lead to one question: the power of judicial review over state action and the state's power to interfere on the basis of these triple limitations with the rights which are given in the Constitution, especially Part 3. So what does it translate to? The first dramatis personae, there are three dramatis personae here: society, state, and the judiciary. Society's practices are subject to these triple limitations, and those triple limitations are invoked by the state in order to codify an existing practice like the Shariat Act, or to curb a certain practice, let's say like the triple talaq legislation. Okay, the judiciary is effectively going to sit not in judgment on societal practice, but state action with respect to societal practice. Okay. So when a societal practice directly becomes the subject of discussion and adjudication by the judiciary without any intervening state action in between, that is a textbook case of transgression of the limits of constitutional morality and violation of basic powers of, let's say, the separation of doctrinal powers. Okay. So the point I'm trying to make is, I don't believe that constitutional morality was ever meant to kill moral diversity, and there is scintillating literature on the certain point. Apart from the constitutional question, on the desirability question, basically say, the very beauty of democracy is different dispensations have the power to bring to bear their worldviews. And therefore, moral diversity is championed by the election system, where every 5 years you get to decide what kind of morality would you want to foist, because that is effectively the scope or of the power that you get when you get elected. Therefore, if constitutional morality were to become a weapon in the hand of the judiciary gets to defeat an elected mandate beyond what is permitted by the state or beyond what is permitted by the Constitution, and therefore you are creating constitutional immutability or moral immutability using constitutional morality, and you're saying that these set of principles are effectively valid for the entire society for all time to come, regardless of who comes to power with what worldview and what agenda. That defeats the mandate of the process, that defeats the express language of the Constitution, and it makes a mockery of moral diversity, which is to be facilitated and fostered in a democracy.
All right. Mrs. Sai, how many more questions can you accommodate with the time? Because we are 7:28 p.m. right now. So how many questions?
For at least another half an hour.
All right. So,
so we have Ramya next.
Okay. Ramya, would you like to ask the question?
Yes, Professor.
Yes, go ahead.
Professor, I absolutely loved your previous point you just said, but circling back to Article 17, my question was related to the fact that, Article 17...
A humble request. I'm hard on hearing in 1 year. Can I request you to be slightly more audible if that's okay?
Yeah. Can you hear me now?
Yes, please. Yes.
Okay. So my question was regards to Article 17. So the text of Article 17 says that, it provides for the abolition of untouchability in any form. And even within the Constitutional Assembly debates, there was an amendment on limiting the definition of untouchability to religion and caste, which was rejected by Ambedkar, and the Assembly itself voted it down. So my question is twofold. One, why is this interpretation not a valid interpretation of untouchability where it has a broader meaning and scope? Secondly, given the fact that the Constitutional Assembly debates can lead to multiple interpretations, should we just reject relying on such historical discussions and assembly debates for the basis of our interpretation, given the multiplicity of answers you can come up with?
Right. Okay. So let me rephrase your question to understand what are the operative portions of your question. Correct me if you think I'm twisting it to my convenience. Okay. Your basic point is Article 17 specifically contains the words in any form. Okay. Thereby giving it a significant amount of latitude when it comes to application, or let's say when it comes to the context and the spaces to which it can apply and lend itself to, point number one. Point number two, since an amendment which was proposed during the course of the Constituent Assembly for defining this particular concept was rejected, effectively it is unbound by any context and therefore can be applied everywhere. That's your point?
I mean, I personally wouldn't use unbound, but more or less, yes.
Okay, fine. Okay. If it's okay with you, a few cross questions. Can I ask a few questions?
Oh, definitely, Professor.
Yes, please. Okay. Which organ of the state, according to you, gets to apply Article 17? In what context?
It's not limited to any state organ. It's applicable to everyone.
No. So basically, it says abolition, right? It's a top-down caveat, right? Agreed?
Okay. Yes.
So my question is, when a certain practice is accused of untouchability, okay, and not state action, I am saying when a religious practice in a religious place is accused of untouchability, I am asking you a simple question, whether a writ petition can be filed against a religious place invoking either Articles 226 or 32 on grounds that that religious practice violates Article 17.
Professor, can I answer that, or was that a question to me?
No, it's a question. Please go ahead, answer this question. Please go ahead.
The reason they were able to do that, going off your previous point, which I think was absolutely valid, there was state intervention, right? There was a state law. Kerala passed a law which necessarily made this like government intervention was involved. Therefore, that gave basis to question the religious practice in of itself.
Right. So, would you agree that notwithstanding Justice Chandrachud's outcome with respect to untouchability, the only reason that the court was even able to consider it was because of state action, right?
Yes.
Okay, thank you. Now, second, was the legislation, according to you, codifying an existing practice, or was it an artificial intervention independent of a certain practice? If you want, I can rephrase the question in a simpler format.
I would appreciate if you could rephrase it.
Okay. Assume for a moment that there is a practice and the state decides to pass a law recognizing that particular practice. Okay. Is that the same as the state passing a law in the absence of a practice?
Right. So they basically made it into law. It was already happening. That was true for triple talaq as well.
Shariat Act, correct? Right? Okay, done. Thanks. Okay. So I'm making a distinction. So I'll circle back to your question without evading it. So if I try to do that, please be a litigator who's cross-examining the witness and remind me the question if you think I'm running away from it. Okay. So I'll come back to your question of whether the history is effectively meant to act as a limiting agent to this chemical reaction. I'll come back to that. Now, the point I'm trying to make is, if a legislation codifies an existing practice, it gives effect to existing rights under Articles 25 and 26. That legislation is not at par with any legislation that creates or, let's say, recognizes a new practice in the absence of a pre-existing practice. Because a legislation that effectively codifies an existing practice is codifying rights under Article 25 and is not the same form of law as envisaged in Article 13 is the argument that is being made in court, which is to say, even if that particular legislation did not exist, rights under Article 25 would have protected those forms of practices and those rights. Okay. So this is not an instance where the state is actually creating certain rights. The state is merely recognizing those rights, and the non-recognition of the state through a legislation of those rights would have made no difference to the constitutional validity of those rights. Okay. Now, what does this translate to? In the absence of the codifying legislation, the judiciary would not have been able to preside over that particular religious practice directly. A writ petition would not have been lying against that particular practice directly. Now the argument is, since the state has made the mistake of effectively codifying an existing practice, a practice under Article 25(1), which was previously unamenable to a judicial review under Articles 32 and 226, has now become amenable only because the state has passed a legislation recognizing that practice, unfortunately. Okay. Therefore, the state has exercised its power as the guardian of the people to codify a certain practice, thereby making my practice more vulnerable to judicial review under Articles 25, 26, 32, and 226, and giving the judiciary an opportunity to apply Article 17. Okay, this is effectively one of the arguments that we're raising, saying if a legislation merely recognizes a pre-existing practice, that legislation must effectively be distinguished from those legislations which are artificial insertions. That's point number one. Point number two, coming back to your question, Justice Chandrachud deals with the history of the Constituent Assembly debates in the context of untouchability, including, let's say, points made by K.T. Shah, and there was another gentleman, a Muslim member of the Constituent Assembly, who specifically made a point with respect to how busybody litigation will be furthered. If you have the assembly debates in front of you, why don't you actually share the names of the people who participated in this particular discussion? Because these were the very people to specifically highlight that ritualistic untouchability and ritualistic practices will also become the subject of writ petitions. What is the point that I'm making here? You want to effectively read into the fact that since that particular definition and the amendment proposing that particular definition was left untouched, therefore Article 17 is not necessarily to be shackled by that particular definition or that particular context. Okay. Now, the Justice Chandrachud's own opinion in this particular regard effectively says Dr. Ambedkar remained silent when that particular definition, or let's say that particular amendment, was being proposed. He did not take a position. So neither was there an acceptance nor a rejection. Okay. He just left it untouched. He left it completely. So therefore, we are reading into a certain form of silence. The entire Sabrimala judgment on the issue of Article 17 is effectively hinging on what to make of that particular silence. Okay. Whether that silence is to be treated as a rejection of a limitation such as a definition for untouchability, thereby making the definition applicable across the board or not. Now here, I will draw support from two other developments. One is the 1955 legislation with respect to protection of civil liberties, which is directly flowing from Article 17. Why? Article 17 effectively is a caveat by the Constitution that untouchability shall be abolished. But to ensure that there are sanctions for violation of that particular rule, the legislations, multiple legislations come out from the state to ensure that there is an actionable means. And each of those legislations is tied to the question of caste. Each of those legislations is rooted in the history of caste. So when it says untouchability in any form, it speaks of the one word that is missing but must be read into it is social untouchability in any form. Okay, which means that the womb that you have taken birth from or the community that you come from is being used as the basis for keeping you out. Now try and extrapolate this particular logic or even apply this logic to the Sabarimala practice and the incongruity will bear itself out. One, it is not based on caste. It applies to a specific gender and not even to a specific gender, but certain groups within that particular gender based on a certain reason that is associated with the nature of the temple. Now, is this social untouchability? Because the distinction that was drawn in court, at least by the people who were representing the temple side, and I'm drawing from Mr. Parasaran's argument, is untouchability is to be recognized as a social reality even outside the temple. That is when you effectively are committing untouchability, because you're saying that not for a particular place, but in general you're an untouchable. Therefore, from wells to places of public interest and to places which are otherwise available to the public, you will not be allowed. Which is why in my previous answer I said Article 15 is equally relevant to the discussion on untouchability, because the idea was to ensure that nobody is denied or deprived of access to public spaces because of social untouchability. That's a social construct. Okay. Therefore, even when it says untouchability in any form, I am caveating it by saying it means social untouchability in any form, not ritualistic untouchability for the purposes of a specific religious institution which has a specific meaning. Second, why is Article 17 taking that particular position? Because it takes the position that untouchability is fundamentally discriminatory, right? Now, for a moment, let's assume that the Constitution does not have a provision such as Article 17 at all, abolishing untouchability, okay? In such a situation, what would happen is that untouchability as a practice remains a social reality with respect to which the state has the power to take a certain position. I am saying, in fact, you forget state having to take a certain position. My point is slightly different. Even if Article 17 was not present, Article 15 could have been used to effectively reach the same conclusion as Article 17. Because both of them refer to public spaces, they broadly say that in social transactions, you will not observe this principle or this particular concept of untouchability. So Article 17 is a clarificatory provision which makes it abundantly clear that the concept of untouchability is abolished, and its absence would have made no difference to the same conclusion through Article 15. Therefore, the entire approach to untouchability is through a social prism, is through a social lens, and the gaze is social in nature. So in any form, those three words don't take away the basic argument that in a certain space, if untouchability is being observed for the purposes of purity, I'll give you a simple example. In several temples, you're not even supposed to touch the priest. Forget touching even the sanctum sanctorum or the murti inside the sanctum sanctorum. You're not supposed to touch even the priest. And the priest is going to observe this practice independent of the caste of the person who's coming inside that particular temple. Therefore, the reason is not social. The reason is ritualistic. The reason is religious. Now, I will take this to a step further because I've encountered this question so often. Because the argument is going to be that untouchability itself used to find scriptural sanction. Therefore, how do you call it just social and not religious, right? So what makes untouchability only social untouchability, and why not religious untouchability? Here's the answer to that. I'm sorry, there's a power cut here. Religious scripture provides untouchability, or let's say assume that it provides untouchability in two spheres. One, in social transactions, and second, in religious transactions. Those aspects of the scripture which effectively have the, let's say, the consequence of engendering or encouraging social untouchability because of a certain birth are the ones which are effectively within the scope of Article 17. Whereas if untouchability is being practiced within a religious space, regardless of the identity of the person who is at the receiving end of that particular practice, then it is not birth, nor is it social considerations at play. It is consideration of ritualistic purity. Which is why, assume for a moment that I were to completely agree with you that there was no definition for untouchability, and it continues to say in any form. To divorce the concept of social untouchability from Article 17 is to say that all forms of rules which respect religious purity and ritualistic purity in a space, in a religious space, must effectively also be treated as falling within Article 17, you will pit Article 17 directly against Article 25(1) and Article 26, because those institutions have the right to observe their practices, including practices with respect to ritualistic purity. So you will violate the rights of practitioners of the particular way of life, and you will also violate institutions which uphold those ways of life for a specific limited safe space, namely the institution of worship or public worship, even it's a public place of worship. Article 17, therefore, was never meant to kill rights which are otherwise part of Article 25(1) or Article 26(b), which is to manage religious affairs of denominational religious institutions. And therefore, rules of conduct within the particular institution are entirely within the autonomy of that particular institution, and they will decide how you will enter and how you will not enter. Tomorrow, let's assume that some person chooses to come inside the temple in an inebriated fashion, not just forget, let's say, even a temple, even in a mosque, he comes in a drunk manner, and people effectively shun him from the particular institution for having violated the protocol of the particular institution. He is then going to use this particular judgment to say, untouchability, because I'm not allowed to enter this particular temple, because I have the right to drink, it's my private right, I can consume whatever I wish to and come inside the particular temple. If that is the level to which we choose to push untouchability, forget history, you will be pitting the entire intent behind Article 17 against express rights which form part of Articles 25 and 26. That's my answer.
We have Anujay next.
Yes.
A very good evening, sir.
Yes.
Anujay, can I just interfere one thing? Sai, this is Shayan. I think this is going to be the last question for you, because there's plenty of people on the line, but there's some institutional limitation on our part also, because we.
I don't have a problem. Just for public consumption, I'm clarifying. I am not running away from any question citing paucity of time. It's the institution saying that it's
yeah, we completely take the responsibility for the paucity of time. Okay, Anujay, so your question is the last. Go ahead.
Very good evening, sir. I'm a recent law graduate from Jindal Global Law School, and you've already answered most of my questions, although I have one regarding, consensus of judicial minds. Yeah. So to give you a very brief background and to give acknowledgement, Professor Alexander Christoph Fischer from Jindal Global Law School, and I had done certain research which was also presented by Professor Fischer in a seminar in ILS Pune, and along with Mr. Arvind Datar. Okay. Now, the last part of our research was concerning certain empirical findings about the use of
Constitution. This was in March this year.
Yeah.
This was in March this year. I missed that particular.
Yeah, this was in March, March 14th, I think.
Yeah.
So So in this particular part, like in the empirical study, we found out after researching on 19 recent cases from Manoj Narola and a case before Manoj Narola, including 5 constitution benches, we found out that there have been mostly like 9 to 10 judges in the apex court who have used the principle of constitutional morality in their judgments. Okay. Out of these 19 judgments, mostly there have been 7 judges, and out of these 7 judges, around 2 judges make up 80% of the jurisprudence on constitutional morality. Justice Deepak Mishra used around 93 instances of constitutional morality, and Justice Chandrachud used around 92 instances. So I just wanted to ask you, do you feel that there's a lack of consensus within this unelected judicial institution itself about what should be the ambit of principles like constitutional morality and transformative constitutionalism? That's it.
I hope this is not a bait expecting me to comment on certain judges of the Supreme Court, but be that as it may, I'll take a position. It is my view that to expect consensus, even in an institution, especially in an institution such as the judiciary, would be to close our eyes to basic human diversity. I don't think that's ever going to be possible. Okay. Second, I don't have a problem with multiple people having multiple views. I certainly have a problem when certain views are passed off as, let's say, the view of the Constitution. Okay. At least be honest enough to admit that it is your view. don't necessarily couch it in the name of constitutional morality. Okay. And if you really want to give it the facade of constitutional morality, then allow us to subject you to further criticism and greater examination without necessarily being visited with other consequences. Okay. That is something that I would certainly expect. That's point number one. Point number two, I think it's time that we rejected the facade of neutrality when it comes to judicial verdicts. Ideological neutrality, worldview neutrality. I'm not talking about political neutrality. I'm being very, very clear about this. If other jurisdictions have effectively recognized the concept of liberal judges and conservative judges, and we seem to be very fond of citing judgments from those jurisdictions, why don't we embrace their honesty in effectively saying, this is my position, this is where I stand on certain social issues? Okay. I would suggest, which is to say that judges to some extent must come clean on these aspects, because you see, they seem to be very, very comfortable holding forth in front of the media on these aspects, on issues that they're either seized of or not seized of, which effectively is going to affect their ability, or let's say the manner in which they deal with certain matters. These matters has been to basically say, as lawyers, you must have the humility to accept that our training is limited to the law significantly, and our exposure to other subjects is limited. And just as we expect non-lawyers to respect our expertise when it comes to the law, we must equally respect the expertise of others when it comes to other subjects, like let's say history, sociology, statistics, and whatnot. Okay. So the tendency to hold forth on everything and wanting to come across as an expert on everything under the sun is partly one of the reasons for such judgments coming out with bombastic statements. Okay. Second, I think similar to the US, on the appellate side, when judges get appointed to the High Court, we must be very, very clear about what is the pattern that emerges from their judgments on constitutional matters. Okay. Especially in matters that concern human rights, matters that concern religious practices, so that we know what to expect when this matter ultimately goes to the Supreme Court, should the same person occupy that position in the Supreme Court. Okay. I have a simple question. Ram Janambhoomi at the end of it mentions 5 judges, and the impression that's given is that it's a unanimity around this concept of an addendum to a judgment, where there is an addenda to the Ram Janambhoomi judgment, and there are very specific and critical findings in that particular addendum, which for some weird reason are not part of the main judgment. So what is the relationship between these two parts of the same document? Are they to be treated as part of the same document? If so, why are certain contentious aspects and certain sensitive aspects left in the addendum and not in the judgment? So the overall point that I'm trying to make is we might as well be a bit more candid with respect to our positions, because we don't live in the age of neutrality anymore. There is no political neutrality relating to caste on matters relating to civil rights. Okay. If you believe that your position is justified, have the courage of your conviction to effectively say, this is what I believe in for so-and-so, so-and-so reasons. So this ultimately ties into the question of transparency of a different nature when it comes to judgments and judicial conduct. Independence of the judiciary is one aspect of it. But I certainly expect as a practitioner to understand which person holds what view, because ultimately that view comes to bear on certain specific cases. Okay. I think I've made my point in a fairly candid manner. Beyond this, I don't want to be accused of stretching the resources of the institution. If there's anything else, please let me know.
Okay, Sai, we'll have to, one second.